to go right into our questions right now. It looks like right now we have about 26 and counting questions. So a lot of questions this morning. Before jumping into the Q&A, we received a few general questions regarding CC&Rs and how to amend CC&Rs. So we want to make sure that we're going to start out with those first. So the first question is, how much does it cost to amend CC&Rs? It really just depends. What we offer as a firm is we do a free CC&R review for the amendment purpose, and we spend 15 minutes on it. And as part of that free review, we tell you what the percentage is to amend the documents, and we give you some general ideas about things we may want to amend. And then we also will give you an estimate as to how much we think approximately it will cost. The cost usually is somewhere between $2,500 and maybe $7,500, with more likely being on the lower end of that spectrum, depending on how many changes there are and, how old your documents are. And sometimes the board has a lot of questions, and that oftentimes will cost more for the association. So if you're interested in, finding out, okay, how much is it going to cost my association to amend the CC&Rs? One thing you may want to do is email our firm at info@mulcahylawfirm.com and ask for a free 15-minute review of your CC&Rs. Now, in order to do that, you must be a board member for your association. And your board must be aware that you're doing that on behalf of the association before you can contact me, because we want to make sure that this is going to be provided to the entire board for your community. Okay, the first question is, our association's CC&Rs have not been updated since they were first written in 1964. Whoa. With the exception of, we did do an addendum about no rental properties. Should we start by revising the CC&Rs first and then move on to the bylaws and rules? What's the best order for our HOA to review and rewrite these documents? Well, since the documents are so old, I think the CC&Rs are the hardest thing to, amend. The bylaws, in my opinion, are really simple to amend, and the rules are really simple to amend. So I think knowing the facts that your association has been around since the 60s, you probably have some pretty serious revisions that need to be made in the CC&Rs. I'd start there. And what I would do is maybe if you're using our firm to help you, I'll tell you, like, hey, the bylaws are going to be no problem. We'll just add those on and the rules. But if the bylaws need a lot of work too, we may want to talk about doing it in phases. But more likely than not, if you're hitting up the owners to vote on something, make it easy for them. Just have one ballot and do all the amendments at once, because it's so hard to go back every year to get the vote. So I would lean more towards, doing the changes to both of the documents and having the owners vote on them at the same time. Okay, question 2. We had to condense this question because it was really long. At our last board meeting, we approved a landscaping change for one homeowner to replace gravel and add drip lines with a provision for reimbursement if all homes got similar updates within 2 years. The HOA is considering more yard flexibility for homeowners. After this, the Landscape Strategy Committee recommended giving homeowners more freedom in front yard landscaping, including grass, gravel, plants, and beds, with the homeowner being responsible for all costs and no dues discount. Plans would need to be board approved before any work starts. As a board member, I'm concerned about how these decisions fit together and would appreciate some guidance. It seems this could be a complex issue. Okay, so the board in your association approved a landscape change to replace the gravel and add drip lines. I don't have your CC&R, so I don't know, does the association maintain this area? And that's why you're concerned. Does the owner maintain this area? I mean, it seems pretty normal that if an owner wants to make an architectural change like this, that it would be approved by the association. Although you had said there was a caveat here that, there's going to be a reimbursement if we have all owners get similar updates within 2 years. So it appears that, the owner was going to pay for this themselves. And if we decide to do this for everybody in the future, we'll give you a reimbursement. Okay, I don't know what your CC&Rs say, but it seems like you're being reasonable in your approach here. The HOA, wants more yard flexibility, and then the landscape committee said you can have more freedom. So I think kind of it's a tug of war here. I think what I'm understanding from the question in that, you have a certain type of landscaping and owners want to make changes. You've already allowed one at the owner's expense to pay. Now the landscaping committee is saying, hey, you can have more freedom. As long as it's not conflicting with anything in your CC&Rs that you're allowing, I think this should be fine. It's really hard for me to give, feedback on something like this without seeing the CC&R. So that's just my general impression based upon the facts you've given me. I'm not as concerned as you are, let's do it like that. But if you are going to change the maintenance of the front yard to the homeowners, which sounds like you're inching in that direction, you probably do need to make a change to the CC&R as an amendment so that it's clear who's responsible for the front yards in the association. And maybe you're allowing all these changes and the associations can still, maintain these areas and they're okay with that. Okay, question number 3 from a board. Is our management company permitted to charge owners a fee for processing a required tenant registration for renters, including short-term rentals? So as I just said in our section before we went into the questions, we can charge a $25 fee. The association can charge a $25 fee. Now, I don't know if the management company is getting that directly because of the contract you have with them. But under the law, the association can charge that fee. And then maybe there's a contract that says the association must pay, the management company $25 each time that happens. I don't know. I haven't seen the documents, but yes. Under the law, that fee is allowable. And if they don't pay the fee and give us those 3 categories of information that are required, you can charge an additional fee of $15 for them being late and giving that information to the board. Okay, next question from a board. Number 4, our association has not enforced the CC&Rs in recent years. What's the right way to start enforcement? Should we begin with a board vote, board approval, or committee visit? Many are unsure how or who should take the first step. Your firm has explained the process well once violations are identified, but we need guidance on how to get started. Okay, so great question. So maybe you've had more lenient boards recently, and now your board is like, hey, we're going to come in and we're really going to start enforcing some of these things that are a problem in our community. I think, yes, the board should talk about this at a board meeting and vote on it, vote that you're going to be starting to increase enforcement activity. I would send out a letter to your homeowner saying that the board on June 17th had a meeting and we talked about this issue and we are going to be, really strict on weeds and trash cans and painting of homes and whatever are the things that you want to start enforcing, and give them a heads up. And then I would start out by doing a courtesy reminder notice to everybody who, doesn't comply after you do your drive-through and come up with the names. Just make it a very courteous, friendly reminder that this needs to happen and it's not happening currently on lot or property. And then you can go into the more serious demand letters and maybe even escalating it to the attorney at a certain point. So ease into it would be my advice with those suggestions. Okay, question number 5. Can you explain the difference between restating a governing document and amending one? Is the distinction primarily based on the extent of the changes being made, or are there other legal or procedural factors that determine which approach is appropriate? Okay, really good question. So if we're taking the CC&Rs, document A, or the bylaws, document A, and we are making so many changes that it's basically, we're not going to be voting on each one of the changes because we have like 10 plus changes. Usually there's like 50, 60, 70 changes, when you're doing an amended and restated CC&R. So basically, if you're doing extensive changes, what you want to do is just amend and restate the old document. And this is now the new document. That's what you're telling them. The amended and restated CC&Rs, the amended and restated bylaws are now the only CC&Rs for the association. So if you had a set from 1964, and then you had your First Amendment, your Second Amendment, your Third Amendment to those 1964 docs, and then you want to just redo them all at once and put all those changes into one document, make additional changes, then you just call it the amended and restated CC&Rs and the amended and restated bylaws. And then that document will trump everything else. Now, if you're just making a couple of changes, I would do like a First Amendment to the CC&Rs. Just, if you're not restating it, you're just making changes to a couple of sections. So hopefully that is a good explanation that you will be able to follow. Okay, next question, number 6. What is required from an owner who lives in another country who wants to give the tenant their homeowner rights? So the owner should fill out a designated agent form and make the tenant their designated agent in writing for the association. Okay, question number 7. One board member has not paid assessments in over 3 months and is near the top of the delinquency list. Does this disqualify them from holding office or having a seat on the board or participating in the discussion regarding their delinquency in the executive closed session? I would need to see your association's documents to see if one of the requirements for being a board member is to be in good standing. It's usually not. It's usually not something that I see regularly in documents, but if we're doing amendments, that's something we might write in. So I'd have to see your documents to see if it disqualifies them from serving on the board anymore. Probably it doesn't. And probably, they would still be able to hold office, have a seat on the board, but they should be excused from executive session if you're discussing their file, that homeowner's file that's delinquent. They shouldn't be there for that discussion as a board. They should recuse themselves and leave the meeting. And no special, privileges or rights for somebody that's on the board. You should be on them just like you would be on any other owner to pay. Okay, next question. Number 8, owners are required to have HOA insurance, but after a recent fire that destroyed a unit and damaged other areas, one owner did not have that coverage. What steps should the board take to ensure all repairs are completed and paid for? So it sounds like your association had a fire, and it sounds like one of the owners didn't have any coverage, insurance coverage, and now we don't know what are they going to do to rebuild after the fire. I would start by reaching out to the owner and just find out what their intentions are. Do they have the money to pay for it? Is it maybe something that could be a claim that maybe the association could make on their policy to help rebuild it? So I would say the first step would be reach out to the owner and find out what their intentions are, and then talk with your legal counsel about how you should handle it going forward in terms of making a claim, forcing the owner to rebuild. There's lots of different questions that will come up as part of this. Question 9. Does the board have to approve a pool movie night for the community? I would say yes, because common areas are being used and because there's a special licensing requirements to run movie nights. I really would encourage the board to request approval from the board before you do that, or an owner would do that. Like there's some liability concerns. There may need to be special insurance for that evening, which isn't that hard to get. It's not that expensive, but you may need to get like a one-day special policy for that. You may need to hire lifeguards for that to make sure that it's a safe event. You may need to have a discussion about glass in the pool areas and alcohol in the pool areas with whoever the organizers are, and also make sure that they're not violating any copyright or trademark laws by having a movie up that, potentially will need to pay licensing rights for it. So lots of issues with movie nights. I love them. I think it's a great idea to bring the community together, but having it be run by the board and talking about these issues is a really good idea. Okay, question number 10. My declarant-controlled association CPA firm failed to deliver the previous year's audit report within the statutory deadlines of the Planned Communities Act. Although this was an anomaly deviation from the firm's past performance, and although the board received a verbal explanation, is it reasonable for the board to ask the firm for a written explanation for what caused the delay? Absolutely. They should be willing to do that. No problem. And that, time period to have that, the audit done, audit review or compilation done within 6 months of the financial, books closing for the year. I've never seen anybody get sued for that, for not meeting that requirement. Lots of times CPAs get really overworked, and some of our clients don't get them until July, August, or September. So, yes, you want to comply with the law, but it's not something that it seems like people get real fired up about it and sue over it. Okay, next question. Can a delinquent owner, number 11, can a delinquent owner defeat the 18-month behind rule by periodically making a payment or a partial payment? So you're talking about the new law. which is going to be going into effect 90 days after the legislature closes. So yes, that is a very smart way for a delinquent owner to handle their payments so that they don't get foreclosed on. They can be strategic and, just always keep it just under, the 18-month mark, being delinquent in the payment of their assessments, and then they know they can't be foreclosed on. Okay, question number 12. Some members asked for a copy of a meeting recording, but were denied. A board member recorded the meeting, but said it was for personal use, not an official board recording. In the past, people in the audience have also recorded meetings for their own use. How can we address this issue and ensure access to meeting recordings? So I think every board should really kind of think about this in light of the new law when it goes into effect this fall. Like, what is our policy for our association? Are we going to start audio or videotaping meetings? It's really easy to do it on Zoom if you're having your meetings on Zoom. Or are we not going to? And come up with a policy on it. And really, if a board member is recording it, it probably is a book and record of the association. If they're recording it, it may not be for their personal use. So you may want to have some sort of a policy in place as to how these are going to be handled. And if, make it clear that if an individual board member is, videotaping or audio taping something, that it is or it is not a book and record of the association, and that the association is doing it instead, and how you can see a copy of it, etc. And our firm can help you or your association or any other association with creating a policy like that to comply with the new legislation. Okay, next question. To finish that one, how can we address this issue to ensure access to the meeting recordings? You should put it in writing and send a letter asking for it. And again, the new law doesn't go into effect until 90 days. So after the legislature closes. So, you don't have any teeth on this until then. But you should be asking for it in writing, and it's a regular books and records request. If they don't comply with it, then you'll have legal remedies by filing a lawsuit or going to the ADRE to have them, rule in your favor on that. Okay, question number 13. If the HOA has a large number of properties owned by one rental management company, how can the HOA prevent the company from being a majority voting block and overriding the wishes of actual owners in the HOA? That's really interesting. So, even though a rental management company is maybe handling the rentals for an owner, the owner really should be the one that's still voting on the ballot, not the rental property. So the rental property shouldn't be signing the ballot. It should not be ballot. If the rental property is doing that, the owner should be signing the ballot. So, I'm not sure that what they're doing maybe those ballots shouldn't even be counted. But a good thing to do is, if you're starting to see this in your community, is, put it out there in a newsletter and be like, hey, we have some concerns regarding the fact that a lot of people are using and don't use the particular management company, but the same management company. And that is creating, a situation where, maybe the other owners, decision-making or what they want is being outweighed by, this large voting block of people that are managed by the same property management company. I don't know. I think it's hard to prove that. And the owner is the one that has to vote. So I'm not really sure there's too much you can do. I don't really think that the message goes anywhere. So if you say, well, we're upset that this management company has a lot of rental properties in here that they're managing, it may be because they do a good job. And, people start talking and be like, hey, they do a good job. In my experience, I really haven't seen that affecting the voting, because the owners are the ones that are doing the voting. Okay, question number 14. I'm just going to do a quick check to see how many questions we have. We have 30, it looks like we're at 29 questions. Okay, question 14. What can our condo HOA do if a contractor did poor work on an amendee and refuses to fix it? For example, our tennis court fence poles are peeling because the contractor didn't sand or prime before painting. When I showed him photos of the issue, he questioned their validity. Now, since he hasn't received final payment, he's locked the tennis courts and posted a sign saying they're closed until further notice, essentially holding the courts hostage until he's paid for substandard work. What are our options? Well, whoa, that's very upsetting to me that a vendor would put a padlock on your property. So I would cut that off. number one, and remove that sign. Number two, I would just go back to the vendor and be like, here are the pictures, here's the situation, look at the contract of the vendor, and just let them know, hey, if you don't fix this, we're going to go to the Arizona Register of Contractors and make a complaint against you. And they'll send an inspector out there and they're going to look at the problem. So we really highly recommend that you just handle it. If they don't do that or still don't fix it, you may need to go to court and get, an injunction or, sue them under the terms of the contract, for them failing to perform. But the Register of Contractors is kind of an easy and cheap way to handle that. So threaten that, and hopefully they'll come around. You have every right to cut that lock off of the tennis courts and remove that sign. And in your response to the tennis court vendor, if you hire our firm to do it, we will tell them that that was inappropriate and, potentially actionable in a lawsuit for them, trespassing on the property and, putting that lock on the property is illegal. Okay, next question, number 15. We are a condo HOA. Each building has 4 units and 1 shared laundry room, which is currently designated in the CC&Rs as a limited common element. The laundry rooms are for the exclusive use of these 4 units. Can we amend the CC&Rs to allow owners within unit laundry to opt out of using and being responsible for the shared laundry room? I think you can amend your CC&Rs, but I'm not really sure how that's going to benefit anybody. Like, are you thinking that there'll be a special cost for using the laundry room? I'd have to learn more about that. I mean, you certainly can do an amendment to, define, how laundry rooms are used or who can use them or whatever, but, and maybe even implement a fee for those who are using them. That's different. Although you would need their approval, but everybody needs laundry, so I don't think that would be that difficult. Well, I think what I would do is I need to know more about that. I think it's manageable. There's something we could come up with, but I need to know more facts and see your documents. Okay, question 16. We have an owner who is routinely verbally abusive to board members, screaming at us in person and hanging up on the phone. The homeowner never comes to meetings, so we can't set limits there, but does things like chasing our contractors with garden implements. Is there something we can do about this behavior? Perhaps a formal letter of some kind for the board or for from you. So I would definitely have our firm send this particular owner a letter, a demand letter telling them to cease and desist. If they are in fact chasing people with garden equipment, you could call the police and have the police do a police report as well. And I don't know if this is rising to the level of you need to get an injunction prohibiting harassment against this owner yet, but the behavior seems a little odd. I would like you to look at our cheat sheet on how to deal with the community association bully and also dealing with difficult people and harassment. We're going to be sharing those with everybody on Zoom and Facebook Live. You can also find those on our website, and those give some great tips on how to effectively handle really difficult people. And there's a discussion in there about getting an injunction prohibiting harassment that might help you. But I do think a letter is a good idea, and I would recommend that you reach out to us and we'll help you with that. Okay, question number 17. I was told I could not ask our HOA lawyer a question about the manager and the 4 other board members wanting to push me off the board. Is it legal for them to speak with the attorney about me, but I can't reach out to the attorney with my questions? The manager sent me an email saying they may send me a cease and desist because I was defending myself on Facebook. They held a special meeting at 1 p.m. last week knowing I would be at work. They knew I work 9 to 5. The backlash was that I was missing the meeting on purpose, so I defended myself for missing it. Okay, it sounds like you guys have a high level of dysfunction on your board, and I really would recommend that you bring in our firm to do a boot camp so we can talk through some of these issues and have the board, 4 board members and you there, and everybody needs to air their grievances and try to hash it out and make sure that everybody knows their rules going forward, and we just deal with the legal problems that might be facing your association. It is unusual that one board member would contact me. I really prefer having, the board, majority of the board directing one person. But having one person who's in the minority contacting me, it becomes problematic for me because it almost appears to the other board members that I'm, teaming up on them, which I never have. So I really would much prefer to meet with everybody on the board in a boot camp and talk through these issues, and hopefully we can all move forward. Okay, next question, number 18. With municipalities requiring new subdivisions to have HOAs and many people ending up in HOA communities who don't want to be, is it reasonable to have the CC&R state that the HOA just follows local municipality law, or it follows these laws except the following? The following would be like paint colors for association, more restrictive weed control, etc. I really don't think that that's the way to go, because municipalities have very lenient restrictions, and the CC&Rs are always going to be more restrictive than whatever the ordinances are for whatever city, town, or municipality you live in. So I don't think it's reasonable. I think that associations are held to a higher standard, and your owners expect more, and they want you to enforce the CC&Rs. Now, you may want to, dial down the enforcement with an amendment to the CC&Rs if, a majority of the board agrees with you. But generally speaking, I would not advise to just follow the local municipality laws. Okay, question number 19. Should board-approved resolutions on water damage, no restrictions on flooring, etc., as required by changes to state laws and contrary to existing CC&Rs, be signed by the president and provided to all owners and recorded by the county? So I don't like resolutions for associations. I think that they're confusing. If the board makes a decision on something, it should be reflected in the minutes, and that would be the formal record of what happened. I would never advise to record a resolution. I would never advise to record minutes. Okay, next question, number 20. Our docs show 5 to 15 board members may be voted onto the board. How can we manage that for our next election? Well, the board should just vote prior to the ballots being sent out for, how many members there are in the community, right? How many board members there are, and, that there's 3 seats up for re-election, and there's a total of 5 board members. Just be clear what exactly it is, how many board members you have, and that's the size of the board that this current board wants. Okay, next question, number 21. What do you think about utilizing a sunset provision versus grandfathering when changing CC&Rs? I'm not really sure what you mean by utilizing sunset provisions. I think it's kind of the same concept. Like, we're allowing people to do it if they want to. And then any new owner that moves in would not be able to do it. I think grandfathering provisions are fine. I'm not really sure what you mean by sunset provisions. Okay, question number 22. Our condo CC&Rs say that amendments must be approved by 67% of the owners and 75% of the first mortgages and beneficiaries on deeds for most changes except common recreation areas, which require all. How do we get around this? So documents that were written in the 80s, the 90s, and to a certain degree, maybe like up to 2005, they sometimes have a weird provision. It's on the more rare side. I'd say like maybe 10% of the amendments we do to CC&Rs, we see this, where it says that you have to get the 67% approval of the owners, and then you also have to get the 75% of the first mortgages and beneficiaries on the deeds of trust. This is just a really outdated provision, and I wish I could say to you, oh yeah, you can just pull that off. But you really can't, because it's in the CC&Rs, and the CC&Rs are a contract. And if you do the amendment and it passes and someone doesn't want it to pass, what will happen is they'll sue you for not complying with the section. So there's a way to comply with it. First, I would amend this section out of there. So when you're voting on the amendment, one of the votes should be get rid of this section saying you need 75% of the mortgage beneficiaries on deeds. And then what I would recommend is the ballot, try to get the 67%, which is what you need, of the owners to approve it. And then once you get the 67% of the owners, I would get a list of first mortgagees and beneficiaries on deeds from a title company, and then send out a letter to all of them by return receipt requested, mail, and indicate in the letter that, by signing the return card for the return receipt requested, you have approved this amendment. And because they don't really know what to do with this when it comes in. Truly, it's such an outdated thing. They don't know what to do with it. But the reason why I'm saying comply with this and check the box is because if you've got an owner that doesn't want something and we're, voting on it and we don't follow this provision to get the first deed of trust or the first mortgages and the beneficiaries on deeds, they could sue us for not doing that and win. So we've got to just check the box. So the suggestion I gave you is our firm handles it and helps you. If your association is in this position, please reach out to us. We'd be happy to help you. Okay, question 23. Can bylaws be considered a part of the CC&Rs or are they always distinctly separate? They should be always distinctly separate. Okay, question 24. Our challenge to amending the CC&Rs is that the current document requires 75% yes vote to pass. Generally, and in the most recent attempt to pass a change, we have less than 60% of the homeowners who responded. We've developed a CC&R committee, gone door to door, as well as snail mail and email messages. Do you have a strategy that gets homeowners to vote? Well, I would say a good way to get people to vote is do it in conjunction with an annual meeting. That's typically your highest percentage of time that people will participate. Have coffee and donuts at the park and talk about the amendments to try to get people to vote. I think a lot of the things that you're doing, going door to door, sending emails repeatedly to people with the blank ballot, all they have to do is sign it. These are all good strategies. And, if you're struggling, I would encourage you to reach out to us and maybe you can take a look at what you're doing and give you some suggestions on some things that might help you to get more votes. Keeping that list and keeping track of what everybody is doing in terms of how they voted is really helpful because you don't want to keep contacting people that have already voted. You just want to limit that list to those who haven't voted and keep reaching out to them. Okay, next question, number 25. Can renters attend monthly meetings and provide comment? Only if the board lets them or allows them to, or only if the owner makes them their designated agent in writing and provides that form to the association. Okay, question number 26. If a tenant refuses to comply with the 48-hour notice to inspect a property and claims medical reasons but doesn't provide medical proof, what are the options, please? So I'm not really sure what you guys are like, how you guys are trying to get in there. Is it like an urgent thing, a health and safety thing, or is it, maintenance thing, or is it just like a check the thermostat kind of thing? I would, sometimes people aren't feeling well or sick or they have a spouse that's dying of cancer. I probably would just open up the lines of communication and write them back and be like, what would be a good time for us to do it? And we understand that you have some medical issues right now. When would be a good time for us to come in and do it and why we need to do it? Hopefully that will get the dialogue going so that you can get in there and inspect the property when the person is up to having you in there. Let's see. Next question, number 27. How do you handle a homeowner that is renting out their other bedrooms even though they live there too? CC&R state single family use. I would go to your city, town, or county that you live in and find out how they define single family use. And usually it's 3 unrelated persons. But once you find out the information, if they are violating that, what you may want to do is make a code violation against them, like file a complaint, and likely the city will enforce it. Okay, next question is, how do we require the landlord to provide the tenant names and license plates? What can you do if the landlord doesn't include everyone who's living there because it's over the allotted amount based on the CC&Rs? So you can send out the letter to them asking for the categories of information and charge them the $25. If they don't provide it to you, you can, charge the $15, which is mandated by the statute that, you can charge that. I mean, really, the only way you're really going to get them to do it is having judicial intervention. So you could go to the ADRE and file a complaint against them. You could go to Superior Court and file a complaint against them to get this information. Now, you're going to have to decide in your mind, is it worth it? Like, how much money do we have to spend to do this? And is it worth it to just get the license plates and the names? It may be if they have so many extra people in there, like you're saying, but that would be the path that I would take. Okay, next question, number 29. What defines planned community? We are a small homeowners association of single-family detached homes where homeowners have responsibilities for everything within their plat. The common area is mostly limited to streets, sidewalks, and some grassy areas. No pool, clubhouse, etc. Are we a planned community? You know, the only way I can tell is if I look at your CC&Rs or a deed for your association. The things I'm looking for are, does the association own the common areas? Are you paying taxes on the common areas? And let's see, anything else that I would be looking for? You know, are the owners required to pay assessments would be another question I would have. So it's hard for me to answer it without seeing your CC&Rs. If I had to guess, you likely are based upon what you're telling me, but I need to see your CC&Rs to give you a specific answer. Okay, final question I think for today is, you spoke about a movie night, but how do you recommend we handle social gathering with food on our common areas? No glass? Does the board need to approve? I mean, I think it really just depends on how large the social gathering is. I mean, because I'm dog walking my dog almost every night, and I may be talking with some people that are also walking their dog. I don't consider that a formal social gathering, but if someone's planning a rehearsal dinner or a special theme party and they're using the common areas, you will definitely want them to come to the board with what they're planning to do, and maybe the board's going to require them to get extra insurance. And so likely, yes, if it's an organized thing where there's going to be more than 10 people, you probably do need to have board approval. Today we had 174 attendees at peak, plus anybody who joined us on Facebook Live. So amazing turnout today. Thank you very much for being here. Want to just mention a few procedural things before we sign off. We are not having First Fridays in July due to the 4th of July holiday. So the next virtual live First Friday event will take place on Friday, August 1st. We have a class coming up in July, a neighborhood services class that we teach in conjunction with a number of different cities. And that's going to be on July 15th. And it starts at 11 o'clock, just like today. And it's going to be on Zoom and Facebook Live. And we're going to be talking about how to enforce CC&Rs. So lots of questions on this today. So how do we enforce CC&Rs when you live in an HOA or in a condo, and how to best handle lawsuits and fines and violations and rental issues and parking problems and refusals of owners to pay assessments and owners who make changes to their property but never get approval. We're going to cover all of that. We'll also have a Q&A session at the end, so make sure to bring your questions on any enforcement issues or any other issues. So that's it for today. Just want to say thank you again to everybody for joining us. Have a safe, happy, and healthy 4th of July. And I will look forward to logging back on July 15th for our next neighborhood services class with you. Take care, everybody, and have a great rest of the week.